Welcome to Law a la Carte, and I'm very pleased to be co-sponsoring this with the New York State Bar Association, the premier bar association in the country. Of course, it's our bar association, and we think it's the best. And I am happy to introduce the president-elect, who will convey her remarks by video. Not that video, I don't know how they're doing it. And her name is Gutekunst. Gentlemen in the back, how are we doing her remarks? Are we ready?
Good morning and welcome. I'm Claire Gutekunst, President-elect of the New York State Bar Association. I'm sorry I'm not able to join you in person for today's terrific program. The New York State Bar Association is delighted to be co-sponsoring today's event on such an important development in legal practice in New York. Limited scope representation, also called unbundled legal services, creates opportunities for attorneys to get involved in helping low and moderate income clients in a way that is more manageable and sustainable for the attorneys, and thus makes it possible for more low and moderate income New Yorkers to get help when they so critically need it. Simply put, limited scope representation means a lawyer can advise a client on a specific portion of a legal matter without being required to provide representation covering the entire legal matter. Last year, the State Bar's Committee on Professional Ethics issued an ethics opinion that offers helpful clarification on how lawyers can take on a limited scope representation and comply with the rules of professional conduct. I know you'll be hearing more about the ethics of this representation later today. Limited scope representation is responsive to the reality in which so many New Yorkers live today. While our state continues a steady recovery from the 2008 recession, there are still thousands, indeed tens of thousands, of New Yorkers who are struggling to regain lost ground. An estimated 80% of poor and low-income state residents currently face, alone, legal problems related to fundamental needs like employment, housing, government benefits, custody, and divorce. Limited scope representation can help fill this need. In March, our association gave one of our top honors, the Angelo T. Cometa Award, to attorney Russ Bleemer and the Monday Night Law Clinic of the New York City Bar Association, a clinic that has helped so many low and moderate income New Yorkers with free 30-minute consultations. Many of these clients are then referred to a lawyer referral service where they can get reduced rate, limited scope help. The experience at the Monday Night Law Clinic shows both the pressing needs and how attorneys can help meet these needs. Since 2008, the number of clients they see and the number of attorneys who are generously volunteering has more than doubled, to the point where the clinic has run out of room. It's not unusual for lawyers to be found counseling clients in the hallway. Well done. For many, the availability of limited scope representation means the difference between getting some legal help or having to navigate a serious legal problem entirely on their own. Limited scope representation is also responsive to attorneys who want to provide needed help but cannot afford to take on an entire case on a pro bono or reduced fee basis. Events like today's go a long way toward arming each of us with more knowledge of how we can help to close the access to justice gap in our state. Thank you for taking the time to learn more about limited scope representation. Enjoy the program.
Good morning, everyone, and welcome to this important program. As the judge said, I'm Bill Russell, and I co-chair with Claire Gutekunst the New York State Bar Association President's Committee on Access to Justice. Claire is sorry that she couldn't be here in person today to welcome you, and I think we're both sorry that her televised remarks couldn't be played here this morning. I apologize on behalf of the Bar Association for any technical glitches. But the State Bar Association is very happy to be co-sponsoring this event with the Office of Court Administration's Access to Justice program. Today's event is important because it provides practical, nuts and bolts information about developments in limited scope representation, which can help our profession address the vast unmet legal needs in our community. Just as important, however, is that events like this one bring together interested lawyers and other stakeholders on the front lines, legal services providers, pro bono attorneys, and members of the judiciary together in the same room. Through sharing of ideas and information, together we could find and forge creative solutions and leverage the resources we have to best serve New Yorkers. Serving the public is one of the State Bar's core values. We do that by encouraging public service and pro bono work by our members and by recognizing and supporting their efforts in a variety of ways. This includes recognition through our Denison Ray Awards, Pro Bono Awards, and the Empire State Council program. It includes advocacy at the state and federal level for sufficient funding for legal services. It includes direct philanthropic support through the New York Bar Foundation. It includes the association's sponsoring of a variety of high-quality training programs for pro bono lawyers. And equally important, if not more important, it includes sponsoring events that bring stakeholders together to share information and ideas to enable all of us to help address the justice gap through programs like the State Bar's Partnership Conference and through events like this one. If we're going to make any headway in fighting to close the justice gap, it'll be through creative solutions like those being discussed here today. So on behalf of the State Bar, I want to welcome everyone and thank you for your participation in this event. Thank you.
So, why are we here? I'm sure that some of you are here for the 6 free CLE credits. And that's okay. Because if you listen with open ears, I'm happy with that. Some of you may be here for the food. The bad news is I did not do the cooking this time. And I think most of you, if not all of you, are here because you are concerned about access to justice and the provision of legal services to both low-income and moderate-income individuals. But you may ask me, Judge Fisher, why did you put all of this effort into this conference? And I'm very pleased because we are simulcasting this also to Albany, and so to everybody in Albany, I hope you can see me. Good morning. We're on board? Great. Good morning, Albany. I was just there yesterday. Why? Why is this important to me? And I think that maybe taking you on what I call my journey to unbundling might be instructive. I became the administrative judge of the Civil Court of the City of New York in 1997. Yes, I've been here a long time, and my responsibilities have increased since then. Oh, by the way, do you know who I am? Yes, of course you do. I'm the Director of Access to Justice and the Director of New York, the Deputy Chief of New York City Courts. But way back when I first started, I was just in charge of the Civil Court, the court known as the People's Court, but probably the largest court in the country with the most unrepresented litigants in the country. And I was faced with, particularly at the time, the housing court, where 99% of tenants did not have attorneys, and an increasing number of small owners did not have attorneys. And I was very worried about my ability to deliver justice to the people of New York and what I should do to do that. Well, I was very fortunate to attend an ABA, American Bar Association, conference in Arizona, where I met and listened to Forrest Mostyn. Most people call him Woody. But he is the father of unbundling. And he gave out a stack of popsicle sticks that were tied with a piece of yarn in a bundle. And on each popsicle stick was a task that a lawyer can do. Think about it. What do lawyers do? They prepare documents, they do discovery, they negotiate, they settle, They do hearings and motions, they do trials, and they do appeals if necessary, and amongst other things. And he had all those tasks on a popsicle stick. And he said, untie the bundle, which we did. And he began to speak to us about the need to think about limited scope representation and how that could increase services to low-income people and moderate-income people. Well, I brought that concept back to New York, and we started the help centers and the volunteer program in housing first, which was an advice-only program. But that just did not seem to be enough. There were still people appearing in court without attorneys. The eviction rate was going up. The homelessness rate was going up. And so, along with my staff, who I will introduce you to at some point today, because they are the best in the world, and particularly my chief counsel, Rochelle Klempner, who's standing here in the front, and I'm sure she's tweeting, because that's what she likes to do, because I refuse to do it. We began to think about what we could do. And so we started the Volunteer Lawyer for the Day programs. In 2001, Rochelle and I wrote an article about unbundling and the problems with moving that in New York State. And one of the things we referred to was a survey of judges who knew nothing about the concept of limited scope representation. And we talked about some of the hurdles that the civil practice laws and rules creates in unbundling, all with the idea of moving limited scope representation forward. Now, the world of access to justice since 1997 hasn't gotten any better. Here in New York, we have 1.8 million unrepresented litigants annually in our courts. I'm happy to say that is less than years before due to the Civil Legal Services funding, and those are our heroes. California, I've been told by California people, they have 4.3 million unrepresented litigants. It is the same phenomena throughout the country. We are able to serve a small portion of the low-income community through the Legal Services Corporation, and I'm happy to say that we have the president here today, and he will speak to you. And he would like to serve more people, but the funding is only but so big. The heart's willing, but the money's just not big enough. The United States ranks lower than any other wealthy nation on the World Justice Project Rule of Law, which looks at how everyday people view the legal system. And we rank so low because our record of providing legal assistance. A 2012 survey showed that 26% of the respondents believe that the civil justice system provides untimely and unreliable resolution of disputes. And the challenges increase as the economy is challenging to people and as our population becomes more diversified. We are a diverse country with people coming from different nations, with different justice systems, with different systems of belief. And when they come to this country, they bring all those customs, their knowledge of the justice system, and their beliefs and their languages with them, and they are struggling with the court system. The numbers of individuals who are becoming elderly and are physically and mentally challenged have increased. And the number of people who are eligible for legal services has also increased. It's not a pretty picture for low-income people. So what about moderate-income people? Well, a survey conducted by the Voices of Civil Legal Services about civil legal services for low-income people, moderate-income people said, we're all about people getting assistance in this country. That's what the United States is all about. But what about us, the moderate-income individual who isn't eligible for legal services, who isn't eligible for any service from a legal services provider, who must actually retain an attorney? What do we do about moderate income individuals? Now, I know some of the issues to some of you may be very thorny. Some of you may have ethical concerns, and we'll address that today in a few minutes. Some of you may have practical concerns, and we have a practitioner here today. I also have somebody from the American Bar Association who will talk to you about what's going on in this country, or the country, on limited scope services. And I think he will agree, and I know that New York lags in making it happen. We wrote the article about untying the knot in 2001, and the bundle's still tied in New York. So we're here to learn, we're here to talk, and I hope we're here to move forward on this topic. And the fact that the New York State Bar is participating is a bonus. We come together as judges and court staff, and we do have a color code, which I'll share with you later on your little tags. You should have little dots. Representatives from bar associations, practitioners, pro bono coordinators, law school faculty, and legal services providers. We're all here. We're all here to join the conversation. But I think it's most important to hear who's most affected by this crisis and access to justice. Let a client tell you her story. Listen to the people who need the services. I'm an open book. You guys know me. You know that my journey to unbundling has been long, but definitely steady. I hope that you will take the journey with me at the end of this conference, and that we can move New York further along.